Okay, everybody. Let's start our next lecture here. I think it's lecture 5. Take a look at your handout there. This is going to be our lecture on torts. Okay. For you people that are going to go to law school, torts will be a one year's course, torts 1 and torts 2. So this will be a lot of material we'll be covering about the next hour. You'll have a general understanding of this topic at the conclusion of this lecture. If you look at your definition there, tort law deals with the body of private wrongs. It was developed to protect people from wrongful conduct of others, individuals or government or companies or whatever. A single act can be both a crime and a tort. I think we may have already talked about this in criminal law. But if somebody comes up to you and hits you, can you get them arrested for that? For that assault? Can you get them arrested for that? And the answer is yes, it's a crime. Society says you cannot do that. Can you do something else that said broke your nose? You can get them arrested, but could you also sue them for an intentional tort? And the answer is yes. And that would be the tort action. Okay, so you'd have both a crime and a tort. The case of O.J. Simpson is a case that's taught a lot on this matter. O.J. Simpson was charged with a crime of murder. He was found not guilty of that, but he was sued for wrongful death by the family of the two victims. And in that case, the jury ruled against O.J. Simpson and ordered him to pay millions of dollars. A lot of times people say, well, how can he be found not guilty of the crime and guilty of the tort? Because one of them is a crime and one of them is a civil action, a tort action. In the crime, the burden of proof the state has beyond a reasonable doubt. We talked about that in criminal law. It's the greatest burden you can have, the highest burden you have in law, tilting the scales of justice all the way. In a civil action, the burden of proof is by preponderance of the evidence, the greater weight of the evidence, if you will. Tilting of the scales of justice ever so slightly would be the burden of proof when you talk about preponderance of the evidence. And that would be the tort action. So while he was found not guilty of the criminal case, he was found liable in the civil case in order to pay millions of dollars. Another thing different from the criminal and civil case is in a criminal case, nobody can put the defendant on the witness stand except the defense lawyer. And if the defense lawyer does not call the defendant to the witness stand in the criminal case, the prosecutor can't even comment about that to the jury. If the prosecutor were to get up and say, ladies and gentlemen of the jury, the defendant didn't testify, mistrial, case over right then. In a civil case, you can call the opposing party, you can call the defendant to the witness stand. The plaintiff's lawyer, and they did in that case, they called O.J. Simpson to the witness stand in the civil case, and he had to testify. They could never do that in the criminal case. The prosecutor could not call him to the witness stand in the criminal case because in the criminal case, you have a Fifth Amendment privilege not to incriminate yourself. So the prosecutor couldn't call O.J. Simpson to the witness stand or any defendant in a criminal case to the witness stand. But in a civil case where you're suing for money, the other side can call the defendant to the witness stand and have them testify, which again, like they said, they did in that case. So you can see where a single act could be both a crime and a tort. We'll talk about negligent causes of action in just a minute, where a person accidentally hurts someone. Could they be arrested for that? Could it be a crime if there was drinking and driving and so forth? You may have a crime and a tort action. You may have both of those things, okay? So now we have a general understanding of what we're going to be talking about. We're going to make lawsuits, suing people. That's what we're going to be talking about, okay? You know also about previous lectures, the lawsuit started by filing a complaint, defendant answers, and then you go through all your discovery. So let's go into first thing, we talk about different types of torts, and we talk about intentional torts first here. All right, an intentional tort is, of course, where a person intends to do something, they intends to hurt you. Remember, when we talk about intent, there's a presumption that you intend the natural and probable consequences of your act. If again, in the tort action, if I rear back and I hit you, I didn't accidentally do that. I intended to do it. If I pick up a baseball bat and swing at your head, that wasn't negligence. I intended to try to hurt you, okay? So that would be an intentional tort. So we look, you see assault and battery there. By the way, an assault and battery, an assault can be a tort. The assault is where you rear back. If I were to rear back at somebody and they was backing up and their back was to some steps, Okay, and I reared back, and they took a step back, and they fell down and broke their back, broke their neck or something like that. I'd say I didn't hit them. Well, I didn't have to hit them. The assault was that right there. Okay, if I point a loaded gun at you, or an unloaded gun at you, and you don't know that it's unloaded, and you react, you fall backwards, and you hurt yourself, and you do some act that you hurt yourself because I pulled a gun, and maybe I'm just kidding. I don't tell you I'm kidding, but I know the gun's not loaded, but I pull the gun on you. That's the assault. That is an assault, okay? And if you hurt yourself, you could sue me for that intentional tort. Like, if I'm just joking, don't matter. You didn't know I was joking, and you fell backwards. You did some act. You could have gone and moved, and the car run over you or something like that because I pulled that gun out there on you. And I'd be liable for that, okay? That would certainly be, you sue me for assault. A battery is the actual striking, so assault, battery. Okay, you can sue me certainly for assault and battery. If I hit you and break your nose, you can sue me. Is that negligence? No. Accident? No. That's an intentional tort. Now you're going to see, remember we talked about criminal law, we talked about intentional crimes, didn't we? Just about every crime, there's going to be a parallel tort to it, okay? And you'll see that, where you, as we go through this, you'll see that, we talked about it, that was a crime, yeah, but you could also get sued for it, okay? So assault and battery, that's one there. Intentional infliction of nervous shock and mental distress is the second one. That's called a tort of outrage, all right? And the conduct has to be so outrageous as to shock the conscience of society. And you say, well, hey, lawyer, do me a better, again, put me a formula right there. Put the formula up here. Why didn't you put the formula in there? There's no formula, okay? A tort of outrage, intentional infliction, nervous shock, and mental distress. That's an intentional tort. And it has to be, and the law says it has to be so outrageous as to shock the conscience of society. All right, let's look at a couple of them here. A good example is the Bill Clinton versus Paula Jones versus Bill Clinton case. Bill Clinton was governor of Arkansas. It's facts of the case. He was governor of Arkansas. The Paula Jones, the plaintiff, the one filing the lawsuit, alleged in her complaint when she sued Bill Clinton that a state trooper, that she was at a state function at a hotel, and other state employees were there, that a state trooper came up to her and told her that Governor Clinton wanted to see her. Governor Clinton was governor of Arkansas before he was president. And she goes up to his hotel room with the state trooper. According to her, he exposed himself to her and asked for a certain act. And I won't ever embarrass anybody in here, but I'm not, we're going into great detail about that. But so she filed a lawsuit against him for intentional infliction of nervous shock and mental distress. That was her lawsuit she filed. Now, it was filed in Arkansas. As a result of that, her lawyers started taking depositions and doing discovery. And during their discovery, they found out their depositions and all the discovery that we've talked about. During the discovery, they found out that there was a lady in Washington named Linda Tripp who had a friend named Monica Lewinsky. And Linda Tripp said Monica Lewinsky had given her information, they were friends, had told her confidentially that she was having a sexual relationship with President Clinton. And from the time this happened in governor, he was running for president, now he's president. So the case is going on. So these lawyers from Arkansas go to Washington, and they talk to Linda Tripp, and she tells them this. They end up taking President Clinton's deposition. They put him under oath, and they ask him, have you had a sexual relationship with this young lady, Monica Lewinsky? And he said, no, I have not. Well, as it developed, Monica Lewinsky they took her deposition, and he said he hadn't had sex with her, but she had this blue dress which had a stain on it. And that happened to be semen, and it happened to match his DNA, okay? So as a result of that, Bill Clinton was impeached by the House, He was tried by the Senate and found not guilty, but the country went through all that because of this relationship with Monica Lewinsky. But it all started because of this case in Arkansas for intentional infliction, nervous shock, and mental distress, being a tort of outrage. Now, after the president went through all that, was impeached, found not guilty, the country went through that, all that, a motion for summary judgment was filed in the case in Arkansas. Motion for summary judgment just is a motion saying that to the judge that assuming everything in the plaintiff's complaint is accurate, it still don't rise to the level of a lawsuit, of letting a jury decide it. The law says not a scintilla of evidence to support letting this go to a jury. Have enough evidence to let this go to a jury. The judge in Arkansas granted the defendant, Mr. Clinton, President Clinton's motion, and said that if you take at face value everything that Paula Jones said in her complaint, if you take that at face value, it does not rise to the level of intentional infliction, nervous shock, and mental distress. It does not shock the conscience of society. It's bad, but it does not shock the conscience of society. So do you see how far this, if you're going to file this intentional infliction, nervous shock, and mental distress, you've got to have it has to be big. It has to really shock the conscience of society. And again, you say, well, give me the formula. No. If you was in law school, you'd read about 15 more cases and you get an idea, but every case is different. Every defendant is different. I tell young lawyers this all the time. And so, again, I've told you before, you can't sit here and say, I know what's going to happen in this case. No, you don't. You don't know. Every case is different. But anyway, back to our issues here. All right. Another case you'll study in law school is the Larry Flint versus Jerry Falwell case. Now, in that case, Jerry Falwell was a minister of a big Baptist congregation in Lynchburg, Virginia. Very high-profile preacher in Virginia. Larry Flint owned the Hustler magazine, okay, which is a pornography magazine. And he ran an article on, he called it a parody, he didn't call it an article, but anyway, he ran this parody, if you will, on Jerry Falwell. And it said Jerry Falwell's first time was with his mother. All right. Jerry Falwell filed a legal action against Larry Flint and Hustler magazine for intentional infliction of nervous shock and mental distress, tort of outrage. Same issue we're talking about here. The United States Supreme Court said that was in fact a parody, and that did not rise to the level of shocking the conscience of society. So that case was dismissed by the United States Supreme Court ruled that. So again, you see how high the standard has to be before you can recover on that tort of outrage, if you will. Some cases I have been involved in where they did come to the level of that is there was a situation at a funeral home where the family wanted to keep the body out a little bit longer, and the funeral home said okay, but the body started bloating, it started smelling, and they hadn't embalmed the body. And of course, the family, they couldn't even close the casket because the body was swollen. The family filed a tort of outrage against the funeral home, and they won the case. They said that was a tort of outrage. That shocked the conscience of society. Another case where a funeral home, the people of the funeral home had the body in the casket, was taking it to the burial ground. A couple people were dropped the casket from the funeral home, and the body fell out. They said that was a tort of outrage. That shocked the conscience of society. So you can see there are cases that could shock the conscience of society. But you say, well, you can read 100 cases, and by the way, the good thing about law is that you can agree or not agree with it. And if you're a lawyer, you can go to court and do your case. So again, that's not negligent. That was intentional infliction of nervous shock and mental distress. Okay, let's look at the next one here, false imprisonment. False imprisonment is simply where it's the equivalent, the criminal equivalent of kidnapping. If you take a person and you put them in a room and you lock them in that room, even if it's for a minute or less, it still could be kidnapping, it could be abduction, and it could be false imprisonment. So if somebody takes you by the arm and puts you and locks you in a car, locks you in a room, locks you in a hotel room, whatever, you can get them arrested for kidnapping. The kidnapping you don't have to ask for the ransom. It's just abduction. Once you restrain that person for any time, then that could be kidnapping in Alabama. You would also be false imprisonment, and you could be sued for that. I didn't accidentally lock you in the bedroom or lock you in the hotel room. I locked you in the bed, but I haven't done that. But if I did, that would be false imprisonment. That's a tort action. You could be sued for that. Defamation of character, libel and slander. Okay, all we have there, libel is written defamation. That's saying something wrong. You're saying a lie, telling a lie about somebody, and you writing it in the newspaper, you putting it out on the internet or whatever. And that you could be sued for libel, defamation of character. It has to be false. Okay, and if you said about a public figure, then the public figure sues you. Public figures, by the way, a school teacher, ball player. It don't have to be a politician. I can be a public figure. A lot of people are public figures. Okay, so if the public figure sues you for defamation of character, the public figure has to show you did it with actual malice, that it wasn't, you did it, you knew it was wrong. You had actual malice. New York Times versus Sullivan. I won't go into any detail, but if you go to law school, you will study New York Times versus Sullivan case. It's an Alabama case, by the way. All right, so libel is written defamation, slander is oral defamation. So if I say something about you that is a lie, and you're damaged because of that, that's slander. If I write something about you and you're damaged, you have to prove damages, then you would sue me for slander. It's called defamation of character. Okay? Again, you read 50 cases, but that's what it would come down to, whether or not I did, and if you're a public figure, whether or not I did it with malice when I did that. Fixed hate, ill will, desire to hurt. That's the definition of malice. Okay? All right, let's see here. Wrongful death. We'll talk about wrongful death in a different lecture, but wrongful death certainly is a tort action. If I shoot somebody, now I'm going to be charged with murder, right? And I kill them. Could I also be sued for wrongful death? Absolutely. Now, you could have a wrongful death, which comes under the negligent part too there, though. If I run a red light and I kill somebody, I did not intend to do it, but if I kill them, then I could be sued for wrongful death. And that would be a negligent tort, but it could also be wrongful death. So the wrongful death could be intentional tort or a negligent tort, if you will. Okay? So malicious prosecution, the next one. Malicious prosecution simply, if I file a lawsuit against you knowing that you didn't do anything, I just wanted to cause you trouble, and you win that case, you can sue me for malicious prosecution. What if I know you hadn't done anything wrong and I get you arrested for something? Sometimes when you get into these divorce cases, the parties hate each other so bad, one of them accusing the other one of sex abuse or something like that, knowing they didn't do it, but they accuse them of it, okay? You could be sued for that for malicious prosecution. You also be arrested for perjury when you testify. But malicious prosecution is simply where, let's suppose I say you assaulted me or you did whatever you did. You stole something from me that you didn't really steal it from me, and I accused you of it. You can sue me for malicious prosecution. You can sue me for that, okay? And false arrest and malicious prosecution, okay? Fraud is the next one, okay? Fraud is where you can do this. Comes under contract law too. We'll probably talk about it in contracts too. But fraud is a tort action. That's where let's say I make where you have to show a representation, a false representation. In other words, I tell you this. I think we've talked about this maybe a little bit already. I tell you this is a 2022 Corvette when it's a 2020 Corvette. Okay, is that a false representation? Yes, that's false. Is it a material fact? Is that a material fact? It would be, because of 22 Corvettes would be more valuable than a 20 Corvette, assuming the kind of Corvette. Let's assume let's assume for our purposes here that that's correct, okay? So you have the misrepresentation of a material fact. Number three, it has to be relied upon. In other words, you bought it. I told you it was a 2022 and it was a 2020, and you bought it. What if you didn't buy it? Well, if you didn't buy it, then you're not damaged, okay? And then the fourth requirement under fraud is damages, okay? So let's play this out. I sell you I tell you it's a 2022 Corvette for $80,000. Let's say $50,000. I sell it to you $50,000. 2022 Corvette. I tell you it's 2020, but it's really a 2020. I tell you it's 2022. You pay $50,000 for it. You go to your buddy and you say, look, I just bought a new Corvette from Mark McDaniel. And you say it's a 2022 Corvette. And your buddy says, that's not a 2022 Corvette, that's a 2020 Corvette. And your friend says, what did you pay for that? The man lied to you. And you say, I paid him $50,000. And your friend says, I'll pay you $60 for it right now. And you sell it to him for $60 and you sue me. Okay, my defense is going to be this. I'm going to answer your complaint, and my defense is going to be, number one, I did lie to you. I made a false representation. And it was a material fact. I agree to that. And you relied upon it. You bought it. You were not damaged. You made money off the deal. So I'm going to win my case. See, in law, you got to prove, if you file a lawsuit, you got to prove all the elements of in other words, you can't just prove three of them. 3 out of 4, you got to prove all of them. So in fraud, you've got the misrepresentation, material fact, relied upon, and damages. Okay? And damages. Interference with business relationship, that's another, I don't have a question on that, on the test at all there. I will say that when you a lawyer and you take the case on and your client comes and tells you a story, you need to check it out. Have your investigator check everything out, because sometimes the client may leave something out. Maybe not intentionally, but maybe intentionally. Your case never looks so good as when your client's telling you about it. So check it all out before you get in the courtroom, and you could get embarrassed in the courtroom. So those are the intentional torts that we have. So with that, let's stop real quick here and let's look at some of our test questions that we will have. These are some of the test questions that will actually be on the test, on the examination. Again, I don't go through all the questions, but I go through some of them. All right. This is a test question. If I go over test questions, I'm looking at the test right now, okay? A credit collection agency made many threatening phone calls early in the morning to Liz. The agency may be liable for A, assault and battery, B, common law harassment, C, wrongful interference with contract relationship, D, intentional infliction of emotional distress. Answer is D. Okay, that would be a tort of outrage if a person did in fact do that. Okay. All right. Next is liable consist of A, written defamatory statements. I don't have to go further than that, do I? We just got through talking about that. So the answer to that, liable consist of it, would be A. Okay. The next one is the intentional infliction of emotional distress usually requires the defendant has engaged in extreme and outrageous conduct. 14, and I don't have to go further than that, do I? I just told you that. I just told you the number, by the way. Number 14 on the examination is A. Okay. Let's see here. Be another one here. Let's see. Let's get the number. This number here. All right. Which of the following is not an element of fraud? Which of the following is not an element of fraud? A, misrepresentation. B, damages. C, material fact. D, statement of reliability of product over similar products. Answer is D. That's not a requirement. that's not a requirement. By the way, that's the only question you have on fraud there, so you got fraud covered there. All right, so that's a few of your questions there, and that will be on your next test. And as I go through the remainder of the lecture, I'll try to point out some things I would pay attention to that probably would be on. I won't go through the exact questions, but you might want to pay attention to this. So now let's go to negligent torts. We've talked about intentional torts, okay? Now let's talk about negligent torts, all right? Negligent torts. Okay, what do you have to, you're driving down the road. A person runs the red light, drunk, runs the red light, hits you, and breaks your leg. And you go to, first of all, the person could probably be arrested for a reckless assault, okay? Thank God it didn't, you just, it was bad you got a broke leg, but at least it's not worse, okay? So you got a broke leg, all right? You're going to sue that person. If the insurance don't settle the case, you're going to sue that person. You get a lawyer and sue that person, okay? All right, now what does your lawyer have to prove? What does your lawyer have to prove? Your lawyer has to prove, number one, a duty of care, okay? That's easy to prove. The law says everybody owes their neighbor a duty of care not to injure them, not to hurt them. So number one is automatic. I owe you a duty of care not to hurt you. So if I'm the one that ran the red light and was drunk and you broke your leg, then I owe you a duty of care not to hurt you. Okay. Number two, this is what your lawyer has to prove to a jury by a preponderance of the evidence. It's not a criminal case. It's not beyond a reasonable doubt. It's by a preponderance of the evidence. Number two, your lawyer has to prove a breach of the duty of care. Okay. That is that it was my fault. All right. Now let's go through that. Suppose you have 8 eyewitnesses that say, I ran the red light, okay? And the police get there, they give me a field sobriety test, I take a breath test, they take me in, do a blood test, and they say I'm intoxicated. Let's say I pulled a 0.18. That's pretty drunk, okay? So it shows that. So you got 8 eyewitnesses that say, I ran the red light. You got police officers saying, we took him in and did all his blood tests, and he's drunk, okay? So your lawyer's got that. So, do you care? Breach of duty of care. So your lawyer has put that on. Your lawyer thinks that she has proven that element, breach of duty of care. That is, that it was my fault. But after your lawyer rests your case and says, I proved my case, I get a chance to go I get a chance to come in and defend, don't I? I get a chance to put my witnesses on. Suppose I come in with Aunt Betty, my Aunt Betty, who's over 80 years old, and is a precious lady. And Aunt Betty was with me, let's say. This didn't really happen, but let's just play it out. We're in court now, and we've been in court for, 3 or 4 days already. You've put your case on, you put your witnesses on, and your blood tests and your state troopers and all that stuff, and you're feeling really good about your case. You got a great case. Your lawyer says, we got a great case. You do. You got a great case. But I put Aunt Betty on the witness stand. My lawyer does. And Aunt Betty says, the lawyer says, Aunt Betty, was you driving down the road with Mark when this accident happened? She said, yes, sir, I was. Well, tell the jury what, if anything, you saw right before the accident. And Aunt Betty says, that young lady over there, she ran the red light. She ran the red light. Now, are you sure, Aunt Betty, that Mark over here, Mr. McDaniel, didn't run the red light? And she said, I'm positive. I would not get in this courtroom and ever tell a lie. Because I'm a really religious lady, and I would never tell a lie. I just wouldn't do that. Okay? Now let me ask this, Aunt Betty. Was Mark intoxicated? Was he intoxicated? No, he was not intoxicated. Mark don't drink. He don't drink. I've never seen him take a drop of liquor in his life. He don't drink. And he sure wasn't drinking that day because I wouldn't have got in the car with him. I wouldn't tolerate that. I wouldn't tolerate it, and I wouldn't ride in the car with him if he'd been drunk. He was not drunk. Okay? And then I get on the witness stand. Juries don't like lawyers, so thank goodness I had Aunt Betty driving with me. This didn't happen now, but I'm just telling you this is the way cases go. Okay? And I say that, you ran the red light. And I wasn't drunk. I don't care what the breath test showed and blood test, I don't care what, I wasn't drunk. Okay? Now, here we go. Does the jury have to believe your 8 eyewitnesses and your state troopers and all, and your testimony that I ran the red light? Or can the jury believe Aunt Betty and me? More likely Aunt Betty. Can the jury believe Aunt Betty? And can the jury say that you ran the red light, that Mark didn't run the red light? Don't care if he's drunk or not. Even if he's drunk, I'm not saying that if they believe Aunt Betty, they believe I wasn't drunk. Okay? But suppose they say he was drunk, but you ran the red light. Well, it wasn't my fault. Duty of care, your lawyer's got to prove a breach of the duty of care. That is, it was my fault. Now the jury comes out and rules in my favor and says, Mark, we're not giving the plaintiff, we're not giving you anything. Mark wasn't at fault because we don't think he ran. We believe Aunt Betty. Did your lawyer prove the second element? Answer, no. You say, well, wait a minute, I had 8 eyewitnesses in the state, blah, blah, blah. The jury didn't believe, they believed Aunt Betty. Therefore, your lawyer didn't prove number 2 because the judge will say that's part of it. The breach of duty of care, that's the biggest part about the case most times, the breach of the duty of care. So your lawyer put on all the good witnesses and you did a good job on the witness stand, but the jury believed Aunt Betty, and I probably had a better lawyer than you did, more than likely. Because if that's the facts case, then my lawyer got up and told some good poems and did some good preaching, and the jury liked Aunt Betty or something. You lost. And I've had so many cases like that in my 48 years. You never know what a jury's going to do, folks. I'm telling you, and I'll keep telling you this till the cows come home. I'll keep telling you this, that you never know what a jury's going to do. I've had cases where I've told you before, they come back, juries find my client not guilty, and okay, but anyway, or I've had civil cases, I've defended civil cases, and I've had many plaintiffs' cases. We've got some of the best plaintiffs' lawyers in this building here. We've got Marcus Helstowski and Nick Heatherly, are two of the top plaintiffs' lawyers in this building. They do a lot of really, really great work. That's what they do a lot of. And they're used to proving these cases. So duty of care, breach of duty of care. The next element is the proximate cause. Okay. Let's suppose this. Suppose that I say that yes, I did run the red light, duty of care, breach of duty. I admit I ran the red light. But suppose you already had a broke leg. My defense would be, I didn't cause the broke leg. You already had a broke leg. So the fact that I had a duty of care and I breached duty of care was not the proximate cause of any damages because you already had a broke leg. That's the reason in my discovery, my lawyer's going to want to know all your physical injuries and stuff because you may have already been injured. You may, and then you sue me again. Now, if it exacerbated it, then I could be liable for that. But if it was you had a broke leg and the doctor says, no, this accident didn't do anything more, she already had a broke leg. So yes, I did run the red light, but I didn't. It was not the proximate cause of your damages. And then the next is damages. Okay. So what about this? Suppose you're eating, you get something from a restaurant. I've had people work for me. they'll get takeout all the time, and then there's something happen, and they'll have something in the food, and they take it out, and it's something that shouldn't be in the food, some kind of tube or whatever, something that's in the food. All right, then you say, okay, duty of care, breach of duty of care, that shouldn't be in there, okay? But what were the damages? What did happen? Well, I took it out, and I didn't get sick. I didn't break a tooth. Nothing happened. Well, there's no damages, okay? No damages. Now, I had a case where there was, thank goodness my client did that. They take a bite of, and we settle the case as a non-disclosure agreement, so we can't tell the place or the amount of money. It's a very substantial settlement, but they saw blood in the food that they were eating, and they had eaten it. Okay, thank goodness they kept that. We got it tested. We then sued the place and had all the employees have a blood test. We matched the DNA. By the way, my client got hepatitis because of it. And again, the settlement was in way up there, because you would have a heck of a lawsuit. Duty of care, breach of duty of care, proximate cause, damages, okay? So yeah, in that case, that was substantial. We proved all the elements. They knew we could prove all the elements, and the case was settled with a non-disclosure agreement. By the way, we actually started to go to trial, and it was settled after we started getting involved in down the road in the case there. So those are negligence causes of action. Those are situations where somebody negligently hurts somebody. Okay, so we've talked about intentional torts. We've talked about negligent torts. Okay, now you see down here on your handout, defenses to negligent torts, contributory negligence. Okay, contributory negligence is simply where you say that let's say it was a stop sign, it was a two-way stop sign, and I pull out. But you were going 100 miles an hour. And I said, I looked, I didn't see anything, and I pull out, and boom. And you sue me for you say you're injured, you sue me for running a stop sign. Okay, and I can prove that at the time of the accident, you were going 100 miles an hour. Okay, now I would say my defense would be contributory negligence. You contributed to your injury because you were going, hey, I ran the red stop sign, but he was going 100 miles an hour. So there's contributory negligence there, okay? Now, assumption of risk is where you're in a hockey match, you're playing hockey, and you get hit with a hockey puck, okay? Well, you're assuming the risk when you're playing hockey, you might get hit with a hockey puck. When I used to be one of the owners of the Huntsville Stars, that was before you had the what do you call it, the AA baseball team we got in the Trash Pandas. Okay, we had the Huntsville Stars before that, years before that, and I was one of the owners. And on our tickets that we had, when somebody buy a ticket to come to the ball game, had a little thing on there that said that if you get hit with a foul ball, that the Huntsville Stars LLC is not liable. If you get hit with a foul ball or a bat that goes into the stands, we're not liable because you're assuming the risk when you go into the baseball field that you may get hit with a foul ball. All right, and that would be you're assuming the risk when you go into the baseball field. It's like a hockey puck coming up into the stands at hockey. You might get hit with that. Okay, the hockey team's not going to be liable. The Huntsville Stars, because we had that on the ticket there. Okay. Now, I was also the lawyer for the Southern League for several years, which is the Trash Pandas, they're in the Southern League, and I was the lawyer for the Southern League for many years. we had a case where the foul ball, it was one of these nights like July 4th, and they had the big crowds, and you had the people were in the concourse, and they were in line to get ice cream. This guy had his daughter was on his shoulders, and they were in line to get ice cream. They were not in the field of play. We're not in the stands. They were in an area in the concourse, and a foul ball came through there and hit this child in the head. Okay. Now, I won't say which baseball team this was. It was not the Huntsville team, but could that team use that exculpatory clause, which we'll find out later on about exculpatory clauses, on that ticket or in that contract, okay, that says we're limiting our liability. We can be liable. You can't limit all liability. You couldn't say that if somebody's at the Huntsville Stars ball game or the Trash Pans ball game and fall down in the bathroom and slick, they couldn't sue you. But getting hit with a foul ball or a bat going into the stands accidentally, you could not sue them for that. But this situation was that they were in the concourse, the ball gets through an area and comes through and hits this child in the head. And it hurt the child real bad. Okay. I was representing the Southern League, wasn't representing the insurance, I was representing the Southern League, but my advice was to settle the case. Even though and we did, even though you had the ticket that said that the team is not liable if you get hit with a foul ball, because these people were in the concourse. They wasn't expecting to get hit with a foul ball there in that area, okay? So you can have exculpatory clauses. You can have a clause in tickets, contracts to exculpate the claims against you, but they have to be reasonable. And it's reasonable that you can't get sued for getting hit with a foul ball if you're in the stands, but not if you're in the concourse and you're waiting in line. The lines were too long that night, by the way. They should have had, the lines shouldn't have been that long. And they were, because it's 4th of July game. And anyway, so you can have the exculpatory clause, but you could still be held liable there, okay? So those would be like assumption of risk. Let's see here, comparative negligence. Some states have that where there's comparative negligence. That's kind of like contributory negligence, where you compare the negligence of each party, the comparative negligence, and it's kind of like contributory negligence. Some states call it comparative negligence, okay? But that's not a test question. But the elements of negligence would certainly be these, a test question. These would be, certain elements would be this, so you just look at those elements of negligence there, okay? All right, let's see here. Our next thing is strict liability. There are some torts that it says legal responsibility for harm done to another even when there is no proof of fault. Strict liability is just, you're liable. You have to prove intentional tort, negligent tort. Blasting, for instance. If you're using dynamite to blast, let's say you're building a road or you're doing something, you're blasting out something, whatever, you're using dynamite, and you put up every kind of sign you can put up. It's blasting. Don't enter this area. Don't come here. Don't whatever. This is dangerous, whatever. If somebody gets hurt because of that, I don't care how many signs you put up, you're going to be liable. Strict liability. They don't have to prove that. They got to just prove we got hurt by the blasting. Okay? Some things are so inherently dangerous that the law is not going to let you get away from there. So, well, I didn't mean to do it, or I put all the signs up, whatever. I did all this and did all. I don't care what you did. Okay? Some things, like having a dangerous animal. Let's suppose you have a pet bear, okay, a pet tiger or whatever. I represent some professional athletes. They actually do have pet tigers and pet panthers and all kinds of stuff. But anyway, you tell them, look, you're going to be liable if that, no matter what. You can't put enough signs up that tiger hurts somebody. So let's say you got a bear, all right, and you have it out in the cage. You may have a petting zoo, and you say, well, you can't pet the bear but there's a bear, and you have all kinds of signs up. Don't go close to the bear cage. Another sign, don't let your child get close to the bear cage. Another sign, don't let your child put the finger in the bear cage. The bear bite it off. Everything. You have all these things up. And the child sticks his little finger in the bear cage and the bear bites it off. All right? And you say, well, look, I had all these signs up. Said, you know, they knew better. Mom and Daddy shouldn't let the child get over close to the bear cage. No, don't matter, you're liable. Okay? Because it's strict liability. You got a dangerous animal and you cannot get away. You can't say, well, I did everything I could. No, you can't get, it's strict liability. It's just like the dog bite, okay? There are some dogs, a lot of dogs, you have the one bite rule in Alabama. Before the dog, gets one bite to show whether or not it's a dangerous animal, a dangerous dog, before you could be liable. But some dogs don't get the one bite rule. Some dogs, if they bite somebody, you're liable. Pit bulls, Dobermans, Rottweilers, several breeds that would be, you don't get the one bite rule. I think French poodle would be all right. I got my Labrador Retriever, and I think my Lab would get one free bite. I think it would. But if you got some dogs, it would be classified as a dangerous animal. Okay, so that would be that's got strict liability. Strict liability, just liability without fault. That's strict liability. Okay. Legal remedies. Now you're talking about, okay, so now you've proved, you're down here, you've proved your elements of your crime, intentional or negligent, strict liability. Now what about damages? Damages, look, compensatory damages. That's your actual measurable damages. That's a test question. Compensatory damage. Actual measurable damages. That's your medical bills, time you're off work, you got, they had to supply your car, whatever, play car, whatever. That's compensatory damage, actual measurable. By the way, pain and suffering is compensatory damages. So that's compensatory damage, actual measurable damages. Now, punitive damages are damages that are awarded to punish, the quasi-criminal in nature. Okay, I think that might be a test question too. Punitive damages are damages that are awarded to punish. Okay, in other words, don't do this again. I had a situation where I had a young girl that had an automobile accident. It was an 18-wheeler, and it was the truck's fault, the company's fault. He switched lanes, got over in her lane and hurt her. Her damage, what the result of the accident was, she could not ever have children again. She was a young girl. She was 22 years old. And she could not ever have children because of that was her damages. The insurance company didn't offer her anything because they said that, well, her actual medical bills were not that much. So we'll offer you X. How much? It wasn't much because they said her hospital bills were hardly anything. Medical bills hardly anything. She wasn't off work very long at all. There's not much to this case. Well, I sued for, over $10 million. Okay? And no, the medical bills weren't much. The compensatory damages were not much. The medical bills were not much. She wasn't off work long. But punitive damages, it's a big company. And they were saying, this is just about money. Here, take this compensatory damages and throw in a little bit more, not much. And I thought the fact that this young girl could never have children again because of this accident, never have children, she didn't have any children. And when I talked to the jury, I said, this is not, my opponents over here, big high-powered lawyers, are saying that this is not worth much because of the medical damages. The medical bill's not much. And I'm not competent to even talk about this, but I will try to paint a picture for you. What is it worth for a mother to hold that child right after it is born. What is it worth to see the child take her first step? What is it like to hear the child say its first word? What does it feel like when you take your child to kindergarten for the first day and to drop it off? What's it like to see her graduate from kindergarten to first grade? What's it like? What's it like? What's it like? What's it like when she goes through junior high school? She goes through her first day. And she goes through, gets in high school. And she gets to be in the honors club. What's it like? What's it like to be so proud of your little girl? She's doing all this. What's it like to walk her down the aisle? She gets married. What's it like for her to have a grandchild for her own daughter and for the grandparents? What is that worth? It's up to you folks. It's up to you 12 people. They say it's not worth much. They say it's just compensatory damage. I'm saying punitive damage. I'm saying punish these people for what they do to this little girl here. I'm saying punish them. You say all your life, and this is what I say when I'm talking to a jury. You say all your life what you think don't matter. A lot of days you wake up, what I think don't matter. Well, it does today. This case was in a small county. And I said to these people, this jury in a small county, that let me tell you what you can do. You can send a message today. It's a big corporation that I'm suing here. And you can send a message to me to be in the Birmingham paper. Oh, it might even go as far as Nashville banner. Be Nashville TV. It might get in one of them Google News things, something. It might. But what is it going to take to get the attention of these people in the 27th floor of this big corporate building? I won't say which city. That's where the board of directors' office is. And they've waited on them, board of directors waited on hand and foot by people like us. Big old mahogany walls, thick carpet, everything at the beck and call. They wouldn't know about this case, but they could. You could send them a message. It goes all the way from this little old county right here, all the way to one of the biggest cities in the world, all the way to that board of directors room. And they say, you know what, we better not ever hurt a little girl in this state, in this county, ever again. We better make sure that don't happen. We better take care that don't happen, because these people mean business down here. You set the damages, folks. You tell this what it's worth. And they did. And they came back for more than what I was asking for. Okay? Because that's punitive damage. Now, if you get up in front of that jury and you say, ladies and gentlemen of the jury, punitive damages are punitive meant to, order to punish. And I believe that you should award punitive damages in this case. Thank you. You won't get punitive damages. Okay? You can put all the prettiest charges up there you want to. You won't get much punitive damage. You better tell a story to that. You see what I'm saying about law? You see what I'm saying about talking to juries? This ain't loan closing business. This is not patent copyright business. That all fits. In my world, it's up in front of 12 people and talking to them 12 people and telling them stories. It's not about you can have all the pretty charts you want, but you better have a story to tell. Okay? You better, if you're going to ask for punitive damage, you need to have a reason for that, to award those punitive damages. okay? Now, I hope I've given you a little understanding of this, by the way, compensatory damage punitive, that'll be a multiple choice question there. That'll be in there, okay? So, I hope you have just a basic understanding of tort law. It's a fascinating way to, if you're to make a living, if you're a plaintiff's lawyer and that's all you do. And like I said, I've got some good ones in this building, Marcus and Nick Heatherly, they, real good ones in this, and I've done a lot myself, but a lot of times I turn it over to these real good young lawyers. But you got some, that'd be a good way to serve people. If you're going to be, and like I told my son, he was a prosecutor, I said, well, be the best prosecutor you can be, raising a family with a guy that did a lot of criminal cases, and his daddy, but he was a prosecutor. But if you're going to represent the insurance company, you be the best at it. If you're going to defend and you're going to represent the big corporations, then you be the best at that. If that's your passion, you be the best at it. My passion's been representing the people, and hope I've done good by them in my time. But it's been always enjoyable to talk to you. I wish I could had all of you in where I could talk to you in class or something. But if ever anybody's downtown, I'm right across the courthouse. You can come by and say hi. If I'm not in court, I'll be glad to say hi to you. But y'all have a good week, and I always enjoy this time I have with you. Thank you so much.